Welcome to the deep dive. We're so glad you're here with us today.
Absolutely. It's great to be here.
Now, I want you to start by visualizing a profoundly gross, just a visceral
Oh,
scenario.
boy.
Yeah. Imagine your basement is flooding with raw sewage.
Yuck.
Right. It's a complete disaster. So you desperately hire this plumber who is, notoriously brilliant at fixing pipes, but he is famously chaotic, completely unhygienic, and just a massive liability of a human being.
Okay, I can picture him.
So your contract with him explicitly says in giant bold letters, no assigning this contract.
Which makes sense.
Yeah, you put that in there because you absolutely do not want this guy delegating this highly sensitive, disgusting duty to, like, his even less hygienic cousin. You hired him for his specific pipe fixing skills.
Right, which is a very sensible, albeit slightly paranoid precaution on your part.
Exactly, but here's where the legal puzzle actually begins. So he fixes the pipes perfectly. But then, to settle a massive gambling debt, the plumber assigns his right to receive your payment to a terrifying, knuckle-cracking loan shark.
Oh, wow.
And the next day, you get a certified letter from the loan shark demanding the cash.
That's terrifying.
Right, so your contract explicitly said no assignments. Does that anti-assignment clause actually protect you from the loan shark? Today, we are answering exactly that. How do courts handle the assignment of rights when a contract specifically has an anti-assignment clause?
That's such a brilliant question.
Like, if someone owes you money under a contract, but the contract says, no assignments without permission, can you still sell that right to get paid to someone else?
And hello to you listening. To answer this, we're going to outline a pretty rigorous analytical path today. We're going to strictly dissect the validity of anti-assignment clauses, specifically in commercial leases.
Okay.
And our journey is going to happen in two distinct phases. First, we'll test a statutory argument under Article 9 of the Uniform Commercial Code, or, the UCC.
Right, the UCC.
Yeah. And then we will pivot to common law contract principles, relying heavily on the restatement second of contracts to finally resolve this dispute.
Well, let's start with that first statutory argument. Doesn't the Uniform Commercial Code basically invalidate anti-assignment clauses when it comes to accounts or general intangibles for money due?
It does, generally.
Because in the source material we're looking at today, the assignee actually tried to use Florida statutes, subsection 679.3184, to just completely bypass the lease's anti-assignment clause.
They did. And, you really have to understand why they thought they had a silver bullet here. The general rule of UCC Article 9 is fundamentally designed to keep commerce flowing.
Okay, how so?
Well, think about a small business that sells goods to a massive corporation on, say, a 90-day payment term.
Right, standard stuff.
Yeah, but that small business needs cash today to make payroll. So they take that right to be paid their accounts receivable, and they sell or assign it to a third-party financing company for cash up front. If massive corporations could just put no assignment clauses in all their purchase orders and actually enforce them, that entire ecosystem of commercial financing would just completely collapse.
Oh, I see.
So the UCC generally invalidates anti-assignment clauses for the payment of money.
That makes perfect sense for, the flow of goods and services. So why didn't it work in our case today?
Because the assignee missed a fatal exception. The black letter law for the UCC exclusion is based on subsection 679.104 HESN.
Okay.
The rule dictates that Chapter 679, which is Florida's adoption of UCC Article 9, does not apply to the creation or transfer of an interest in or a lien on real estate.
Ah.
Yeah, and I'll explicitly note the key element here. The exclusion specifically encompasses, quote, a lease or rents thereunder.
Ah, okay, I see. Because real estate is fundamentally different from, a shipment of widgets.
Exactly.
It's localized, it's tied to the land, and historically, property law operates in its own ancient protected walled garden.
That's a great way to put it.
So, because the contract in question here is a commercial real estate lease, that UCC statutory argument just hits a brick wall. The statute simply does not apply to leases.
Precisely. The statute gets thrown out, which leaves us relying entirely on ordinary common law contract principles. And that forces us to take a surgical look at the exact language of the contract and then the exact nature of the assignment.
Let's analyze Aldana v. Colonial Palms Plaza, Ltd. First, what are the legally dispositive facts?
Well, we have a landlord, Colonial Palms Plaza, and a tenant, which was a bakery called Abby's Cakes on Dixie, and they signed a commercial lease.
Okay.
This lease contained an $11,250 construction allowance for improvements to the space. But before those improvements were finished, the tenant borrowed $8,000 from an assignee,
And who was the assignee?
a man named Robert Aldana. They borrowed this to finance the construction work. In exchange for the loan, the tenant assigned Aldana the right to receive the first $8,000 of that construction allowance directly from the landlord.
Got it.
So Aldana, the assignee, recorded this assignment and sent formal notice via certified mail to the landlord.
Smart.
But crucially, the lease contained a clause stating the tenant agrees not to assign this lease without the landlord's prior written consent.
Oh, there it is.
Yep. So the landlord ignored Aldana's notice, paid the construction allowance directly to the tenant once the work was done, and Aldana sued the landlord for the money. The trial court initially granted summary judgment to the landlord, ruling the assignment was invalid, and even awarded the landlord attorney's fees.
And what was the core legal issue?
Does a commercial lease provision prohibiting the assignment of the lease prevent a tenant from assigning the right to receive a specific contractual payment?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the rule from the Restatement Second of Contracts, Section 322, subsection 1. The black-letter rule is this. Unless the circumstances indicate the contrary, a contract term prohibiting assignment of the contract bars only the delegation to an assignee of the performance by the assigner of a duty or condition.
That's a mouthful.
It is, but we break this down into 4 testable elements. First, a contract term prohibiting assignment of the contract exists.
Right.
Second, the assigner assigns a right to receive payment rather than delegating a duty or condition.
Okay.
Third, notice of the assignment is delivered to the debtor. And fourth, there is an absence of circumstances indicating the contrary.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, a contract term prohibiting assignment?
So we approach this with a mini IRAC. The sub-issue here is whether the commercial lease actually contained language prohibiting assignment.
Right.
The sub-rule requires an explicit contractual bar to be present in the document. Factually, when the court examined the lease document, it clearly stated that the tenant agrees not to assign this lease without the landlord's written consent.
Okay.
So the conclusion for this element is straightforward. The first element is met. The contract clearly had a prohibiting term.
Understood. Now, what about the second element, assigning a right to payment rather than delegating a duty?
This is really the crux of the entire case. For our mini IRAC, the sub-issue is characterizing exactly what was transferred from the tenant to the assignee.
Okay, what did they transfer?
Well, the sub-rule, derived directly from the restatement, draws a vital distinction between delegating burdensome duties and transferring the simple benefit of receiving money. A duty is something you have to do, right? A benefit is something you get.
That makes sense.
Factually, the court looked at the tenant's actions. The tenant did not delegate their lease duties. They didn't hand over the obligation to run the bakery or pay monthly rent or maintain the property.
Right, they just wanted the cash.
Exactly. They even performed the condition of actually doing the construction improvements themselves.
Yeah.
What they transferred to Aldana was strictly the right to receive the $8,000 construction allowance.
I see.
So the conclusion here, because the tenant assigned only a right to receive payment and did not delegate a duty, the second element is met.
Understood. Now, what about the third element, delivery of notice to the debtor?
The sub-issue here is whether the debtor, in this case the landlord, was properly and formally informed of the assignment.
Right.
The sub-rule states that delivery of notice of the assignment to the debtor is what legally fixes the accountability of the debtor to the assignee. Basically, if the landlord doesn't know about the assignment, they can't be punished for paying the original tenant.
That seems fair.
It is. Factually, the court noted that Aldana did everything right. He recorded the assignment and sent physical notice of it via certified mail directly to the landlord.
And the landlord just what, ignored it?
The landlord actually received this notice before paying the tenant, but simply chose to toss it aside. So the conclusion. Because formal delivery of notice occurred prior to payment, the third element is met.
Understood. Now, what about the fourth element, the absence of circumstances indicating the contrary?
So the sub-issue here is whether special context in this specific arrangement overrides the standard general rule of construction.
What kind of context?
Well, the sub-rule acts as a safety valve. for highly unusual or intensely personal contracts where assigning money actually would cause harm or alter the deal somehow.
Okay.
Factually, the court reviewed the commercial lease. A landlord paying a tenant a construction allowance is just an entirely standard, everyday commercial transaction.
Right, happens all the time.
Exactly. The court found absolutely no unique, highly personal, or unusual circumstances that would prevent the standard application of Restatement Section 322. It was just a standard debt. So the conclusion, there were no circumstances indicating the contrary, so the fourth element is met.
And after analyzing all the elements, what was the court's final conclusion?
Synthesizing the conclusions from our elemental analysis. Because the tenant only assigned a right to payment rather than delegating a duty, and because proper formal notice was delivered to the landlord, the assignment was valid and legally binding.
Wow.
Yeah, the broad anti-assignment clause in the lease did not block the transfer of the specific monetary allowance. Therefore, the appellate court reversed the trial court's summary judgment in favor of the landlord, reversed the award of attorney's fees, and remanded the case. The landlord, by ignoring the notice, effectively had to pay twice.
Okay, this is fascinating because it fundamentally changes how we view the power of the written word in a contract.
It really does.
To make sure you listening can maximize your memory recall of how this distinction actually functions in the real world, let's revisit that gross, visceral hypothetical from the top of the show.
Ah, the plumber.
Yes, the plumber. So your basement floods with raw sewage. You hire the brilliant but unhygienic, chaotic plumber. You put no assigning this contract in giant bold letters.
Yeah.
Because you absolutely do not want him delegating this highly sensitive, disgusting duty to his cousin.
Right.
He wades into the muck, does the job perfectly, but then assigns his right to receive your payment to a terrifying, knuckle-cracking loan shark to settle a gambling debt. And then you get a certified letter demanding the cash.
It's the perfect vehicle to test the Aldana reasoning.
Okay?
If we apply the doctrine we just learned to your hypothetical, does your strict anti-assignment clause protect you from having to interact with and pay the terrifying loan shark?
I really hope so.
The answer is an absolute no. It does not protect you.
Wait, really? So I have to hand my hard-earned money over to this loan shark? I specifically wrote no assignments to avoid dealing with sketchy third parties.
You do have to pay the loan shark, and the restatement explains exactly why. You really have to look at what was actually transferred.
Okay, break that down for me.
The plumber did not delegate the gross specialized duty of fixing the sewage. That is the performance your anti-assignment clause successfully protects you against.
Right, he did the work himself.
Exactly, he did the hard work. What he assigned was merely the right to receive the money. The law recognizes that paying money does not require a special personal relationship.
Oh, I see.
Yeah, your bank account doesn't care whose name is on the routing number you send the funds to. The burden on you, just writing a check is exactly the same, whether you hand it to the plumber or mail it to the loan shark.
Wow, so the clause protects the work, it doesn't protect the wallet.
Precisely. Because you received proper, definitive notice from the loan shark via certified mail, just like the landlord received from Aldana, the law says your accountability is now fixed to the assignee.
Unbelievable.
If you ignore the loan shark's letter and pay the plumber anyway, the loan shark can sue you, and you might end up paying to the sewage repair twice.
That is a staggering realization. The words, no assignment of this contract, do not mean what the average person thinks they mean.
That's not at all.
So for the listener who needs to actively apply this knowledge, whether they're drafting a contract, dealing with a debt, or, studying for a law exam, I'd love for you to distill everything we've discussed today. Can you give us a step-by-step diagnostic checklist that we can use for issue spotting and exam taking?
I would be happy to. If you are facing a fact pattern with an anti-assignment clause, here is your actionable 4-step synthesis checklist.
Excellent.
Step 1. Identify the contract type. Ask yourself, is it a real estate lease?
Right, the exception.
Exactly. If the answer is yes, you must immediately dismiss any UCC Article 9 arguments regarding the invalidation of anti-assignment clauses for accounts. The UCC real estate exception is an absolute bar. The property walled garden remains intact.
Okay, got it. What's next?
Step 2. Read the anti-assignment clause strictly. Does the text prohibit assigning the contract or the lease broadly? Or does it specifically and expressly prohibit assigning rights to payment?
Right, the exact wording matters.
Well, very much so. Step 3. Analyze the nature of the assignment itself. Did the assigner attempt to delegate a performance or a physical duty? Or did they merely transfer the right to receive money?
The duty versus the wallet.
Yes. Remember the restatement rule. If they just transferred the right to receive money, the law protects that assignment to keep commerce flowing, despite the presence of a broad anti-assignment clause.
Okay, and the final step.
Step 4, check for notice. Was the debtor given definitive formal notice of the assignment before they paid the original party? Accountability, meaning the legal obligation to pay the new person, is only fixed upon the delivery of that formal notice.
That is incredibly clear. Step 1, contract type. Step 2, strict reading. Step 3, duty versus payment. Step 4, notice.
You've got it.
Thank you for walking us through that analytical path so precisely. We want to thank you for joining us on this deep dive into the surprisingly porous walls of contract law. But before we let you go, I want to leave you with a final provocative thought to mull over or explore on your own.
Oh, I like these.
We saw that a broad clause saying no assigning the lease wasn't enough to stop the transfer of the money in the Aldana case.
Right.
But what if the drafter of the commercial lease was a little more paranoid? What if an anti-assignment clause explicitly and specifically states tenant cannot assign the lease nor the right to receive any monetary allowances under it?
Oh, wow.
Yeah. Would the restatement rules still protect the assignee? Or would that hyper-specific language suddenly qualify under the fourth element as circumstances indicating the contrary?
That's a great question.
It just goes to show you how a few extra words of precise drafting might completely flip the entire outcome of a case. Think about that the next time you sign a contract. Until next time, keep diving deep.